Hey, beautiful people. Welcome back. Affidavits. What are the elements of an affidavit? There's a very popular presumption that goes around where people go, an unrebutted affidavit stands as law. The presumption is supposed to stand on some type of contract law. But in truth, that's not how contract law works. An affidavit that is not rebutted does not stand as law. For several reasons. The first reason is the element of what makes an affidavit. Two parties can create what they call an affidavit, but only one of those qualify as what an affidavit really is. Someone can name their document affidavit of so-and-so, affidavit of fact, affidavit of truth. The other party can name their document the verified complaint. The man who names his or her document affidavit of fact or affidavit of truth. If the elements of what makes an affidavit does not express itself within the face and the substance of that document, you can name it an affidavit of whatever it is, all you want. It's still going to fail on its face. That's one reason why an unrebutted affidavit does not stand as law. The second reason why an unrebutted affidavit does not stand as law are the loopholes within contract law and trust law, such as the elements of what you are contending, such as what you intend to invoke to compel performance. If the other party is not liable to what you're bringing down, then that affidavit is just nothing but a piece of paper. And of course, everything written on a piece of paper remains fiction unless performance brings it to life. So let's clear the elephant in the room of all the misconception and vague things that has landed a lot of people in a lot of trouble and have kept people chasing after their tail perpetually. Maxim of law, maxim of contract law, and the agreement of the contracting parties. The rule is to regard the intention rather than the words. The intent behind what you put down is what makes the substance itself, not the words that you're putting down, not that you're titling your document an affidavit. So what are the elements of an affidavit? The purpose of permitting a declaration under penalty of perjury in lieu of sworn statement is to help ensure the declarations contains a truthful fact representation and are made in good faith. Good faith of the declaration. That's one. Two, the declaration has to be under penalty of perjury, meaning you're invoking trust law, that everything you're saying, your word is your bond. That's what perjury is. That's why a lot of people always go, oh, they perjure themselves, because their words are their bonds. These are ancient principles. That's two. Three is you don't always have to swear to it for it to be an affidavit. What is the fourth element of what an affidavit is? Your common law is judge-made law that everyone loves so much. Mogavero versus Kinsler, appellate decision in the year 2000. But you know, if one was not sworn to, meaning the declaration, was not sworn to before an official or person in authority, remember, the swearing can be substituted for penalty of perjury. If one was not sworn to before official, person, and authority, it is not valid. That's 4. It has to be witnessed by someone authorized to act as a witness, by some type of witness with the authority to act as a witness. Again, this first point is that an affidavit, what makes an affidavit is that it must be done in good faith, meaning it's admissible, which is the foundation of everything. If it's done in bad faith, then automatically due process is not being afforded. A lot of people like you doing unilateral contracting, thinking they're going to hold people liable. That's bad faith. So the first and foundational element of what makes an affidavit is the good faith. The second is that it has to be declared. You have to express it. It has to be conspicuous, obvious. The third, it can either be under penalty of perjury if you don't want to swear an oath to it, whether for religious reason, personal reasons, spiritual reasons, or other contingencies involved in liability, meaning you want to finagle the matter the way you want, beyond just how you personally see things. Then you are obligated to do certain things this way. So you don't want to swear to it. You just want to say, you know what, rather than swearing, whether because of my religion or because of the contingency of the situation, I'm just going to tell you my word is my bond. So I'm going to declare to it under penalty of perjury. That's what perjury simply means. My word is my bond. Again, the first element of a contract, called an affidavit, is good faith. The second one is it has to be declared. The third one is it can either be sworn to or declared under penalty of perjury. The fourth one is it has to be witnessed. The fourth one is extremely important. The fourth one, besides the first one, which is good faith, is another aspect that a lot of people overlook. See, when you do this fourth one, we went over a video called attestations or self-authentication. This fourth one, whereby someone witnesses it, is what makes it self-authenticating according to rule of evidence. You want your stuff to hold weight, you want to compel performance, you want to create liability, it has to be self-authenticated. Rule 902, the uniform version of rule of evidence. This part where they speak of before official person in authority, otherwise it is not valid. If one, aka the declaration, the affidavit, was not sworn before an official person in authority, it is not valid, meaning you have to declare it or swear to that affidavit that you made in good faith in front of someone who has a standing and capacity to act as a witness. When you speak of official things, you're speaking of an office. In this case, self-authenticating evidence lets you know that. 902, number 2, domestic public documents that are signed and certified. A document that bears no seal, if it bears the signature of an officer or employee of an entity named in 9021, meaning it has a seal of an entity that belongs to the United States, any state. This any state can be a trust, district, Commonwealth, territory, insular possession of the United States, political subdivision, aka the state of so-and-so's notary, and a signature purporting to be an execution or attestation. In other words, a notary acting as a witness to your signature, not the content and element of the document itself, just the signature itself. It's the official entity spoken of here as a witness, which makes it self-authenticating. In lieu of that, you can also use at least 2 or 3 witnesses. Good faith, conspicuous declaration, which is done under penalty of perjury or sworn to in front of a witness. Good faith being 1, the declaration being the second. Whether you do it penalty of perjury or sworn is the third, the witness being a fourth. What is the fifth element of an affidavit? An affidavit that contains only legal conclusion is substantively deficient. Meaning you can cite all the case laws, all the Black's Law Dictionary, all you want. You can cite all the maxims, all you want, even though most maxims that people state actually don't exist. The people who tell you an affidavit, an unrebutted affidavit, stands as law in commerce, tell them to show you an actual reference to that in the common law that they're going about, or the actual reference of that maxim itself. They cannot. Yet, you know how many tens of thousands of people go along and ride along with it? An affidavit that contains only legal conclusions is substantively deficient. A video was done in the past regarding a chief judge saying, look, we only look at the substance of the document, not what the titles are. And the substance are the four elements we just went over of what makes an affidavit. An affidavit that contains only legal conclusion is substantively deficient. And although formal deficiencies in an affidavit can be waived if not raised in trial court, substantive deficiencies cannot be waived. The substance is what makes a document, which are the things we just went over. A verification is an affidavit attached to the statement as the truth of the matter set forth in the statement, such as a certificate of true and correct copy, or an affidavit of probable cause, or literally a document that just says, quote, verification, meaning a neutral third party is looking at it and saying, yep, it looks like it's true. You want to submit a copy of a passport, a copy of a social security number, a copy of a birth certificate, copy of some type of official transcript, but you don't want to give up the original, just do a verification affidavit of true and correct copy. That's also affirmed the rule of evidence. And that stands as an affidavit also. The case law, Slavenberg Court versus Opus Apparel Inc. in 1981 says, however, even those persons who are statutorily allowed to use affirmations in lieu of affidavits cannot do so when they are party to an action. Meaning this verification has to be by a third party. You yourself cannot verify your own document. Therein lies the importance of a witness, a neutral third party. Similarly, wherein a affiant signed his name to a statement wherein he stated on oath that he had read the attached document, that he knew its content, and that they were true, it was held that the statement constituted proof that he was conscious of the fact that he was swearing to the correctness of the attached documents, and the documents was verified according to law, even though the notary, instead of executing a jurat, executed a certificate of acknowledgement. Certificate of acknowledgement is also on the rule of evidence. This aspect where it declares that it's true is referring to 28 U.S.C. 1746. Sworn declarations under penalty of perjury. I declare, certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. That is the fifth element. What is the sixth element? First-hand knowledge. An affidavit must set forth facts and show affirmatively how the affiant obtained personal knowledge of those facts. Thus, an affidavit that does not positively and unequivocally represent the fact as disclosed in the affidavit to be true within the affiant's personal knowledge is legally insufficient. Meaning, on top of swearing under penalty of perjury, you must state that you have first-hand knowledge to the best of your knowledge and belief. That's the sixth element of an affidavit. See all these elements? You read all these documents and all these people saying they have affidavits. Do they have these elements in it? This is what the eyes of the fact finder, the truth finders, will be seeking for in your documents that you're saying is an affidavit. beyond the actual content of it, of what you're intending to invoke. A video was done as of recent, whereas the mere narration of fact is not synonymous with evidence. The American jurisprudence even goes as far as to tell you, generally, affidavits are not competent evidence and should not be considered by the court as a trier of fact. An affidavit is normally presumed to state matters personally known to the affiant and lacks evidentiary value. This is according to American jurisprudence. In a variety of civil contexts, meaning pen and paper game, when based on information and belief, or hearsay, of course, there are exceptions to that, which we went over. In other videos, affidavits generally can be used for impeachment purposes, absolutely, which we've also went over in the past, but cannot be offered as substantive evidence. An affidavit is ordinarily not admissible to prove facts. So to all you do an affidavit of fact, your affidavit does not prove any fact. Preponderance of evidence does. An affidavit is ordinarily not admissible to prove fact in issues at an evidentiary hearing, because it's not a hearing of whether you have an affidavit or not. It's a hearing for evidence. So bring preponderance of evidence. And your affidavit of fact is not that. You know how many thousands of people have been misled to just do something arbitrarily that they call affidavit of fact, and they think that's it? Now you owe me something. I've just did my notary protest and all the affidavits. Now I got you. All right. Because it is not subject to cross-examination and would improperly shift the burden of proof to the adverse party. However, an affidavit may be admissible. Listen to this. However, an affidavit may be admissible as evidence on a material fact, meaning you have to prove something, meaning in your affidavit you have to attach something and say, see material fact so-and-so, see preponderance evidence so-and-so, see material evidence so-and-so, see exhibit so-and-so. That is how you utilize an affidavit. Always link it to something substantive. Always link it to something with probative value. Always link it to a material fact. However, an affidavit may be admissible as evidence on a material fact at issue if evidence is admissible, generally on the fact as an exception to the hearsay rule. We have went over the hearsay exceptions. There are videos on that on this page that's been went over. Evidence is how you run things, whether formally or informally. Affidavits are not how you run things. That is presuming that you've qualified for the 6 elements that we went over that makes up an affidavit. Take care. Best of luck. And most importantly, stop jumping on the bandwagon. Stop allowing people to mislead you with their hype train. Whenever something is regurgitated over and over, and a lot of people accept it, stop for a moment and you be the one to question it. As the saying goes, when a falsehood is repeated often enough, it simply becomes a truth. People simply accept it as a truth. Whether or not it is truthful or not, people loosely accept it as a truth. Whether or not it damages them or not, people loosely accept it as a truth. And most of those people who loosely accept it as a truth cannot prove why they think it's a truth beyond just the regurgitation of buzzwords. Don't fall victim to that. Know better and do better. A quick shout out to my patrons, and to those who have not yet joined my Patreon, I'm inviting you, come on over. On the Patreon page, we speak about things that are not shown here on YouTube. We speak about the private side of the court, outside of just the finance. We speak about how to prove actual fraud and lift the corporate veil. In addition to some study tools, we speak about how to actually invoke private right of action there in the Bill of Rights. We speak about financial things with letters of credit, property rights, preservation of property rights. We speak about how to put your vehicle in a trust and how to not qualify for tax, how to properly fill out the GSA, public laws of the state and common law, how to establish probable cause. There are different types of damages. There's damage and there's damages. Those are two different things. The type of relief that you seek to be granted is a huge part of the type of damages. We go over that. We speak about the details of the bills of right, which is what you would really be invoking whenever you bring in any claim, whether on a financial level, private level, whatever it is. We speak about how to remain private when it comes to the EOSCAR algorithm and how to establish certain types of profile. We speak about how to go after bonds. We speak of how to get federal judges and other federal employees oath of office and bond. We speak about the different types of discharge and the specific ones, and we go over the details and more and more to come. Take care and best of luck.